Hi, I'm Hatim Kheir, counsel for the Justice Center for Constitutional Freedoms, with your update for Day 27 of the Public Order Emergency Commission hearings. Today was a long day with lots of interesting evidence. We heard from 4 witnesses. 3 testified as a panel of 3. There was David Vigneault, the director of CSIS, Michelle Tessier, who is a deputy director of operations, and Marie-Hélène Shea, who is the director of ITAC, the Integrated Terrorism Assessment Center, which operates independently but within the umbrella of CSIS and reports to Mr. Vigneault. They described CSIS's function and their mandate. They explained that there were people who CSIS was already monitoring who were involved and interested in the convoy, but CSIS did not investigate the convoy itself. An interesting point that came up was a document that talked about the symbols and flags present, and in CSIS's opinion, the racist flags like the swastika or the Confederate flag were brought by individuals who were trying to seem more popular but not part of a broader group initiative. One of the big issues centered around the definition in the CSIS Act of threat to the security of Canada. So I'm going to step away from the evidence for a bit just to give a bit of legal context here. The Emergencies Act sets out different kinds of emergencies. This was a public order emergency. And the standard for a public order emergency requires that there be a national emergency arising from threats to the security of Canada as defined in Section 2 of the CSIS Act. So it takes the definition from the CSIS Act and imports it into the Emergencies Act. And so that's what makes that definition very important. Now, under cross-examination by yours truly, it was put to CSIS that they're the experts in this act, and in their assessment, a threat to the security of Canada wasn't met. And going through the 4 different options that are present in that definition, he agreed that none of them were met, and there was not a reasonable suspicion that any of them were met. And that's a lower legal standard that requires a possibility that something could be true. Now, he did explain that he advised the Prime Minister to invoke the Emergencies Act, despite that threat, him determining that a threat to the security of Canada wasn't present. And the reason he did that is because he was advised by lawyers that that definition, threat to the security of Canada, has a broader interpretation in the context of the Emergencies Act than it does in the CSIS Act. And so on the basis of that advice, he gave his advice to the Prime Minister that the Emergencies Act should be invoked. Now, it's important to note that he acknowledged that he's not familiar with the Emergencies Act and that this was not his own assessment, but rather an assessment he received, again, it was in the context of legal advice. Turning away from CSIS towards the 4th witness we heard, but the second to testify, let's say, and that was Minister Bill Blair. He's the Minister of Emergency Preparedness. One of the things he talked about was the role in receiving requests for assistance. So Alberta requesting assistance was a big part of that. One of the things a couple points actually that I want to focus on. So one, he was not aware on February 13th of RCMP Commissioner Brenda Lucky's opinion that not all police options had been exhausted. So we'd heard a bit about that previously, how that was not, she didn't speak at the meeting like she normally does in order to convey that point. And so he wasn't aware of it. Under cross-examination by my colleague Rob Kittredge, he again came back to this idea that he believed that Section 2 of the CSIS Act has a broader meaning when it's being interpreted in the context of the Emergencies Act than the CSIS Act. He was asked about what threat was present, and he was taken through the different options, and he was pressed on the idea of, asking where serious violence was present. So serious violence is a component of Section 2C under that definition, threat to the security of Canada. And he referred to things like intimidation. He said people felt threatened. He said some symbols on display were threatening to many Canadians. So these were his examples of serious violence. And lastly, interestingly, towards the end of his evidence, when he was about to be examined by lawyers from the government of Canada, some documents which had previously been redacted had been provided by lawyers for the government of Canada with fewer redactions. And so Brendan Miller, counsel for the Freedom Convoy, was allowed to ask a few more questions. And so he put up a document that was a readout of a brief given to ministers on February 12th. And it included the point that the police had a plan, that the OPP and the RCMP had approved it, and it was just waiting for Chief Peter Slowly's approval. So that was provided to the ministers on February 12th, and they were aware of that. Lots of more interesting evidence to come this week as we hear from other cabinet ministers in this last week of the public hearings. Tune in tomorrow for the next update. Thanks, and I'll talk to you then.